because when we're looking at what the IP is that we might exploit, we need to bear in mind, I think, that some of the IP that Andy and Brian bought in good times was actually itself licensed IP from third parties. So we're talking about the company acquiring licenses of images of famous golf courses around the world so that the players can experience immersive gameplay, and whether in fact the company as the licensee can transfer those license agreements through whatever process it's been through in insolvency terms to a new company is going to depend on the assignment provisions and the termination provisions in those license agreements. And I have to say, it was pretty poor drafting by the licensor to allow a licensee to go into administration for that not to be a termination event. And the licensor should have included an express right of termination in the license, because actually in the absence of the express right, there's no common law right to terminate the contract based on the counterparty's insolvency for it to fall back on. Equally, it would be pretty poor drafting by the licensor for the licensee to go into administration and then be free to transfer the license to the highest bidder, so that Anion or anyone else and the licensor would then effectively be forced into a relationship with a third party, which it hadn't originally contracted with. Assuming that those license agreements from the golf courses of the licensors are drafted on terms which do include those sort of standard licensor protections, then Brandy Golf won't be able to transfer those licenses to Anion. And if Anion wants the benefit of the licenses, it's actually going to need to negotiate new license agreements with the golf courses, I would suspect.